Hello, everyone. Welcome to my podcast. I'm your host, Eric, and we'll be getting right into it, reviewing chapters 11 and 12. Okay, so chapter 11 is contract law. What is a contract and who are the parties involved? Well, a contract is an agreement that can be enforced in court where two or more parties promise to do or not do something. The parties are the offerer, who makes the contract, and the offeree, who receives the contract. What are the four elements of a contract? So we have the agreement, where one party makes makes an offer, and the other agrees to it and accepts it. And then we have the consideration. The consideration is something of value is exchanged between the parties, such as money, services, or promises. Then we have the contractual capacity. Both parties must have the legal ability to enter into a contract. And lastly, we have legality. The contract must involve a legal purpose. Okay, what are the types of contracts based on methods of formation? Well, we have express contracts. In these contracts, the terms are clearly stated in words, either spoken or written. And then we have implied contracts. In these agreements, the agreements are formed by the actions or conducts of the parties. Okay, let's go on to number 4. What are the types of contracts based on performance? We have executed contract, where a contract has been fully completed by both parties, and we have executory contracts, where a contract has not yet been fully performed. What are the four types of contracts based on enforceability? Well, we have valid contract, which meets all legal requirements and can be enforced in court. We have the voidable contract, which is a valid contract that one party has the option to cancel. We have the unenforceable contract, which is a valid contract that cannot be enforced due to a legal rule. And we have the void contract, which is a contract that has no legal effect because it involves something illegal. What is a quasi contract? Well, a quasi contract is not a real contract, but it's created by a court to prevent one person from unfairly benefiting at another person's expense. Okay, let's move on to chapter 12. Agreement. So what are the two events that make up an agreement? Well, we have the offer and the acceptance. One party has to make the offer, and the other has to accept the terms of the offer. What are the three elements of a valid offer? Well, we have serious intent to form a contract, we have reasonably definite terms, and the offer must be communicated to the offeree by the offerer. Okay, list 6 situations where intent to be bound in an offer are questionable. Okay, so let's just list them out. So we have expressions of opinion, we have statements of future intent, we have preliminary negotiations, we have ads, we have auctions, and agreements to agree. For auctions, it's the invitation to bid. So, what are agreements to agree, and are they enforceable? Well, agreements to agree are situations where parties say they will make a contract in the future but have not yet finalized the terms. They are usually not enforceable because the terms are not definite. What are 7 ways an offer can be rejected? Well, first up, we have rejection by the offeree, then we have the counteroffer, then a revocation by the offeree, expiration of time stated in the offer, expiration of a reasonable time, death or incapacity of either party, and destruction of the subject matter or illegality. Okay, so some key points about acceptance. Acceptance must be unequivocal, meaning it clearly agrees to the terms. Silence usually does not count as acceptance. Acceptance must be communicated by the offerer. The mode of acceptance must follow the method required in the offer. Acceptance must be timely. And under the mailbox rule, acceptance is effective when it is sent, not when it is received. Okay, some key points about online offers and acceptances. Online contracts often use click-on agreements, where users click I agree. Browse wrap agreements involve terms posted on a website that users accept by using the site. And courts generally enforce online contracts if the terms are clearly presented. Electronic contracts are legally valid under federal law. What type of documents are not included in the eSign Act? The eSign Act does not apply to certain documents such as wills and testamentary trusts, divorce and family law documents, court documents, notices of cancellation of utilities or insurance, and evictions or foreclosures. Thank you for reviewing with me. I hope you join me next time. I'll see you.